Right here, the wagon.
Dad, this is not the car you ordered.
Take it easy, Rusty. Ed, this is not the car I ordered.
You didn't order the metallic P? Mr. Griswold ordered a blue sports wagon. Where is it?
I don't know, sir.
Now, I owe it to myself to tell you, Mr. Griswold, that if you're thinking of taking the tribe cross-country, this is the automobile you should be using, the Wagon Queen family truckster.
I show you how deep the rabbit hole goes.
Like you, be strong to hold the powers of the sun.
Listen to Pavarotti.
Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. And I'm sorry I didn't get the Sunday night special out to you last night. We had a long family day. Got to see Mama and just had a really good day, and I hope everybody else had a wonderful day as well. In today's episode, though, I'm going to shift gears just a little bit, and I'm going to go over a couple of the court docs that came out, I think it was last week, and I've been meaning to get to them for you, but I'm just now getting to them because, it's kind of interesting to have a few wins in the middle of a few losses, and everybody out there just talks about all the losses. So we're going to talk about the latest two rulings that the judge ruled on, and these are wins for the defense. And I checked the case summary this morning. The defense's proffer still hasn't hit the case summary for the alternative perpetrator, which you can bet the entire Dateline special was there to try to steer all of the media coverage away from the defense and their alternate perpetrator evidence. They even mentioned it in that episode. So very interesting there. It's always strategic. But there is a lot of things that we can actually, information we can gather from these last two rulings. One is on Bryan Kohberger's family and their ability to be in the courtroom. The judge ruled in favor of the defense. And then there is what I told everybody that, that secret hearing was about. It was, they're doing a deal, they're doing this, they're doing that. No, that secret hearing, they absolutely discussed exactly what I told you it was, and it was the fact that the state wants to examine Bryan Kohberger. I went through the statute on that and said they're going to have to let them interview him or give him a examination, and that's exactly what it was. And we're going to go over what the judge ruled on that because it is interesting. And then all that talk, you never hear people revise their speech once something happens, but all that talk out there about how the expert that was leaving the case was for the defense, and they just said it was Cy Ray. They said it was the person that died, all this kind of stuff. It wasn't even the defense's expert that left. It was the state's expert that bowed out because they didn't like the tactics that the state was planning on using as it related to that examination. So this is information everybody needs to know. And we're going to jump right into it with Kohberger's family diagnosis. But first, like I said, I'm going to do in every single video going forward until it's acknowledged by everybody. We're going to deal the knockout blow, which is the fact that Elantra is green.
I mean, that's unbelievable.
All right, so I've had people out there accuse me of trying to doctor this stuff up as if I have to. Look, this is the FBI's report in the actual Kohberger court record, the court docs. When you go to the last page, it shows make and model chart number 3, and it gives you screenshots that they used to identify Kohberger's car. This is the FBI. And when you look at these screenshots, particularly this one, and this one, and this one, and you've got the little thing here that makes it bigger. Look, let's just go to 250%, right? Here's the side view. Here's the front view. Here's another side view. And you can already see from this side view, look at this. You can see all the green coming through just at 250. Look, you can practically see once you start staring at this stuff and you realize that it's green, then it's plain as day. Look, that sucker's green. And then look at this. Just from this angle, this is the FBI. Look, you can see the spokes clearly. They go straight across. This one's going to come down to this one. This one's going to come down to this one. It's 6 spokes. And then look at this. You can see the green on the bottom, but look at this. I mean, you can clearly see the license plate right here. I mean, how did we miss this? I mean, Mark B is a genius. How did we miss this thing? Look at this. It's right there. Make it a little bigger. You can see it even better. I mean, look at the green on this car. Look at the freaking license plate. I mean, I'm not adjusting this thing at all. It's just, that's their picture. How did they miss this? Let's make it bigger. 400%. Look at this. It's green. Green, 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 green. Everywhere it's green. The whole car's green. Look at the license plate. It's clear as day. Look, here's the dent. One more time. Let's go to 500. I mean, it's just unbelievable how we missed this. Look at this. You can see it. There's the dent. There's the dent, y'all. Look how green that car is. My goodness. This is just no filters or nothing. This is straight off of their court docs. Okay, so now we're going to the order from the judge on defendants' family members in the courtroom. And in its order on the motion in limine regarding the family members in the courtroom, the court ordered the state to submit for an ex parte in-camera review, and this is part of what went on in that closed hearing as well, a list of defendants' immediate family members it intends to call at trial. So they're not talking about calling all of them, but they were going to try to exclude all of them. The purpose for calling each of them. So what was the purpose for calling each of them? Whether they can be called early in the case and why exclusion from the courtroom prior to providing testimony is necessary. The state timely complied with this directive. Having considered the state's response, the court, exercising its discretion, get the little footnote 1, finds good cause to excuse defendant's family, i.e. parents and siblings, from the anticipated exclusion order that will be entered under Idaho Rules of Evidence 615 prior to trial. Now, why is this little footnote 1 here, and why does the judge find good cause to excuse Kohberger's family members from being excluded from the court? And I'm going to tell you, it's all Massoff on this one. Because when you go down here to number 1, and he writes the reasons why he excludes, why he's not going to exclude them. And number 4 is how he reached that decision. He says, reach its decision by the exercise of reason. And he states State versus Herrera. This is why he decided to let Bryan Kohberger's family stay in the courtroom, though, because he used his exercise of reason. And it was from a strong argument by Massoff. And not only was he exercising his reason, and she hit on that, but she hit on even a stronger term, which was exercise your humanity, Judge. In fact, I believe her exact words were, you need to find your humanity, Judge. Let's listen.
And that is why I specifically talked about the point that it is discretionary for you. And there's also, Judge, a level of humanity that I hope that you take to serious heart for his family, who is absolutely devastated and dealing with things like headlines that they're going to be called to testify against their son with these types of communications that are happening. And so We're asking that you use that discretion and that you find that humanity. Thank you.
Now, on a side note, I also noticed something interesting as I rewatched this portion of the hearing. And as they were having this discussion about Bryan Kohberger's family members, I noticed Josh Hurwitz and Bill Thompson. And Josh Hurwitz wanted to have a conversation with Bill Thompson as the judge was describing how the narrative wasn't going to go in order like the prosecution would like in this case. Check out this interaction.
You are going to put all the pieces that go into that into the pot. And at the end of the day, the jury's going to decide whether it's a good soup or not from the state's perspective. And so I think we get too obsessively stuck.
I sure would like to know what was said in that conversation. But the next things I'm going to point out in these same docs tell us so much. And it also dispels so many of those rumors and lies about what they're going to even be questioning Bryan Kohberger's family about. It practically tells us, and I'll show you why.
The state submits that by simply placing our client's family on its witness list, that is enough to warrant exclusion, and further, that they may call family members. I want to note that they have not subpoenaed them, the state's attorneys have not interviewed them, and they know that Mr. Kohberger's family does not have any interest in helping them.
Okay, so that's clue number one. The fact that they haven't been subpoenaed or questioned by the state, by the prosecutors, tells us that the only conversations that the state has ever had with Bryan Kohberger's family was on the night that Bryan Kohberger was arrested. And their testimony is limited to what's already been recorded. So whatever they said the night he was arrested is the only thing that they will be testifying to. Watch.
During Mr. Kohberger's immediate family were interrogated in the middle of the night when he was arrested. All of their interviews are videotaped.
Okay, so right here it says, under the circumstances here, the court does not find that excluding the testifying members of the Kohberger family will serve this purpose, and the purpose it won't serve is all of the law talk over here about reducing the witnesses' possibility of shaping testimony. But then it goes on to say, namely, the scope of the family members' proposed testimony is very narrow and is not necessarily tied to the testimony of other witnesses. Well, that would negate them testifying about any K-bar knife purchases. Further, the family members were previously interviewed regarding the matters on which they will be questioned at trial. Remember that statement. These prior recordings serve to protect against any attempt by the family members to mold their testimony based on how others testify before them. In addition, the trial publicity is such that defendants' family members are likely aware of what the testimony and evidence will be in the state's case in chief. Thus, excluding pending testimony will not necessarily prevent them from conforming their testimony. Finally, the state has indicated it would prefer that the family members remain in the court and be called when state sees fit rather than calling them as out-of-order witnesses. But there's some really big stuff in this paragraph. Number one, the judge has talked about how it's very narrow of what they're going to be testifying to, and the family members were previously interviewed regarding the matters which they will be questioned at trial, and it's on recording. So I can assure you, based on this, that they're only going to be testifying on what they were previously interviewed on, and it was recorded so they can't change their testimony. It has nothing to do with the K-bar knife, y'all, and I'll prove it. So first, let's go back to the hearing and let's talk about when they were previously recorded and interviewed. Now, that right there proves that they never talked to anybody in Bryan Kohberger's family other than the night that Bryan Kohberger was arrested. That was on December 29th, 2022. At that time, all of the Amazon search warrants had turned up nothing related to Bryan Kohberger, and that is proven through the court record. So when you hear all these media outlets talking about they're going to put, and the mainstream minions, talk about they're going to put Bryan Kohberger's family on the stand and question them related, to his Amazon purchases and click history. It's a farce because, as you just heard the judge say, they're only going to testify to what they've already said on recorded statements, and they couldn't change their statements. So while somebody in his family may have said during that initial interview the night he was arrested that Kohberger owned a knife, they're not going to be asking anything about the Amazon, because the Amazon warrants that found Bryan Kohberger's purchase and click history didn't happen till almost, I think it was May of 2023, when Special Agent Michael Douglas dove into that click history. So the mainstream morons narratives out there about this case, Bryan Kohberger's family, and what they'll be testifying to is just a bunch of BS, as usual. Now, let's move on to the state's, or the order for the state's experts to examine Bryan Kohberger and what that order was about, and who the real expert witness that left the case and why they left the case was, because that is interesting. Okay, so we're going to dive into this one a little bit because it's a long order and there's some interesting things in here. And I mean, I've got to say, there's some things that stand out big time, and there's some things that, I actually agree with the judge on. But as we go through this is the judge's order on the state's motion for the 18-207 examination and extension of deadline. And if y'all go back to the video I did a couple of weeks ago when they were filing all this, I went over the statute 18-207. And 18-207 states that when the defendant initiates psychiatric testing, that in the mitigation phase, in the sentencing phase, the state has the right, once the defendant does that, to engage in the same testing. And basically what that is for is after sentencing is where they house the defendant, in a prison or in a mental health facility. And I thought that was interesting. But you can see right here in the introduction, it says, defendant does not dispute that his penalty phase expert disclosures opining to his mental conditions trigger the state's right under the statute to conduct its own mental health examination. And we know that there's nothing to dispute because the 18-207 4C explicitly states that once defendant does it, the state has the right to do it. So, and they're not disputing that. What is in dispute, however, is the scope of the examination, whether defense counsel may be present, and whether the state has shown good cause to extend the rebuttal disclosure deadline. So, what the state was asking for in this was that they can examine Kohberger, number one. Number two, that they extend the scope of the examination not just to this autism spectrum disorder and OCD and all that, but they wanted to add psychological testing related to personality disorders. So basically they wanted to test so they could say that, Kohberger is psychotic or sociopathic, which would bypass that order that the judge ruled against in the limine hearings, that the state could not call Kohberger a psychopath or sociopath. They were trying to backdoor it with this. And then they did not want Kohberger's counsel, Taylor Massoff, to be present during the examination. The defense wants to be present. And finally, they wanted an extension of their rebuttal phase expert deadline. So they wanted four things in this motion, and this is all brought by Hurwitz. All right, so this is him being slick on this stuff. So let's talk about it for a minute. The oral argument on the motion was held by video conference on May 5th, 2025. So that's what the conference was about. This was the oral argument for all this stuff. And you can see by the judge's order, this must have been a pretty strong argument that they were having about this particular issue. After which the court ruled from the bench, so this order memorializes that ruling. So in that hearing that we did not get to see, the judge ruled, but this is him putting his ruling in writing. And you can see when it talks about the oral argument, and the little number one right here is the little number one. Because the motion was likely to and did generate discussion about issues concerning defendants' mental health, including matters not admissible at trial, the court sealed the hearing pursuant to the Idaho Code to both protect against the disclosure of highly intimate facts which would be highly objectionable to a reasonable person if disseminated, and to preserve defendants' right to a fair trial. Sealing the hearing was the least restrictive way to protect the privacy interest at issue. Neither party objected to sealing the hearing. This is what I find interesting, because I heard so many people out there throwing a fit. Even mainstream morons were throwing a fit that this particular hearing was sealed. And everybody had their death penalty and all this kind of stuff. They're making a deal. No, I mean, this is the only one so far that I agree with that should be sealed, because they're talking about Kohberger's private mental health issues. So this was absolutely one that needed to be sealed, but it's the one they threw the biggest fit over because it was sealed. And that's why I was pulling my hair out, listening to everybody talk about what they were talking about in this hearing, when it was clearly for this right here. So I'm not one to say I was right, but I was right. Then we go into the procedural background. I'm not going to read all this, just the highlighted portions. But it says on April 2nd, this gives us the gist of it. On April 2nd, the state initiated communications with defense counsel about conducting an examination of the defendant pursuant to Idaho 18207. It was initiated by Hurwitz. Defense counsel responded that same day, right on time, requesting the name of the experts, the nature of the testing, and whether there was any objection to defense counsel being present for the exam. So defense team comes out, they're cool. They're like, okay, no problem. Can we get the name of the expert that's going to do the examination? They want that so they can talk to their expert and find out if they know them. The nature of the testing, all right, are they just going to test for autism, or are they going to try to test for some psycho stuff? And do y'all have any objection for us being present while the doctor exams? The following day, the state provided the information requested, including the proposed testing. Among the tests listed was an assessment of personality structure. The state also objected to defense counsel being present. So the next day, the state said, here's our doctor, and we're going to test for personality tests. And no, we don't want the defense counsel to be present because we're going to go in there and do a bunch of shady stuff. In response, defense counsel did not object to the evaluation, but did object to testing outside of the scope of what defendant experts had conducted, specifically personality testing. She also asked the state to reconsider its position of having the counsel present during the examination. And you know what? This right here is what got rid of that state's expert, because they didn't want to be a party to the BS the state was trying to pull. So on April 11th, follow these dates, right? April 2nd, the next day, the following day, and then about 8 days later, on April 11th, 2025, the state's mental health expert informed counsel he was not able to continue on the case. That is absolutely not what happened, and it said in here later that the state's mental health expert informed the state that he was not going to continue, or she was not going to continue on the case, because the state was trying to do personality testing that they didn't want to do, and that doctor would not do that testing unless defense counsel could be present. And the state did not want defense counsel present really strongly enough to where that state mental health expert left the state, said, I'm not doing it. So all of those people out there talking about, Kohberger's experts are quitting. It was the state's expert, and they quit because of crap the state was trying to pull that they weren't down with. Now we go into the analysis. In its motion, the state seeks an order from the court. What the first thing they want a deadline for its penalty phase rebuttal disclosures for 21 days following the completion of the state's expert examination. Now, I'm going to go ahead and let the cat out of the bag on all this. So the state wanted 21 days of extensions for their state expert, rebuttal expert deadline. And the judge rules, instead of 21 days following when they complete the examination, they're getting 21 days from the May 5th hearing. That's what he ruled. He said that 21 days from the examination was too long. So 21 days from the May 5th hearing means May 26th is their new deadline for their mitigation experts. So that's going to be quite a bit less than the 21 days they asked for, because they have to have time to complete the examination. Allowing the state's expert to administer standardized personality testing on defendant, the judge ruled against that. They cannot do personality testing on Kohberger. So that was the big win right there. They can't pull their shenanigans about the psycho or sociopath. And then finally, excluding defense counsel's presence at the examination. Now, the judge did rule in favor of the state on this, which that's kind of scary, because that means they can get Kohberger in there and do whatever they want to him, and his attorneys cannot defend anything that's happening. And that must be a big issue if that's why the state's expert quit the case, because of that particular thing. So we'll need to keep our eyes open on that. Defendant responds that there's no good cause for the extension. Lost that one. It would be highly prejudicial given the posture of the case. Yeah, no doubt there. Personality testing is beyond the scope of the rebuttal and would violate his Fifth Amendment's right to self-incrimination. Won that one. Counsel's presence during examination is required by the Sixth Amendment. Lost that one. All right, so as indicated at the hearing on the motion, the court finds good cause for a short extension to the deadline. As for the examination, personality testing will not be allowed, nor will counsel's presence be allowed in the examination room. All right, so when we go down here, it says, while the state should have filed its motion to extend the deadline weeks sooner, the court is sympathetic to the fact that the state's mental health expert, who had been provisionally retained shortly after defendant's guilt phase expert disclosures, decided to withdraw from the case just 2 weeks prior to the rebuttal disclosure deadline, leaving the state to scramble to retain another expert. What they're really saying here is he decided to withdraw from the case for ethical reasons, so the state had to go find somebody whose ethics were, let's just say, in question, in my humble opinion. Defendant objects, arguing personality tests exceed the scope of proper rebuttal. He points out his own experts did not perform personality testing or diagnose him with personality disorder. Rather, his proffered evidence concerns his diagnosis of ASD, OCD, ADHD, and his history of eating disorders and substance abuse. He also argues nature of personality testing violates his Fifth Amendment right against self-incrimination. Now, I find two things very interesting about this paragraph. Number one, they mention autism spectrum. This is the judge writing. Autism spectrum disorder, obsessive compulsive disorder, attention deficit hyperactivity disorder, and eating orders and substance abuse. Never in here, or never in the opening up here, where he talks about all those disorders, like right here is, all right, autism spectrum, obsessive compulsive, attention deficit hyperactivity disorder, ADHD. Never once in any of this is the judge recognizing, for some reason, his dexterity disorder. What was it called? DXD? His dexterity disorder that the experts are saying would not allow him to even, act like a ninja. The judge, for some reason, omits that in all this. But one thing he doesn't omit is this is his proffered evidence. That means this is evidence that the defense has proffered, has given to the state, and it admits to a history of eating disorders and substance abuse. A lot of people out there have questioned whether it was true or not if Bryan Kohberger suffered from a substance abuse disorder due to past substance abuse. That right there is put to bed. He has definitely had substance abuse issues, as he has proffered evidence around that. So I certainly am believing the news reports of the interview of the guy that spent time with Kohberger in rehab. So one of the defendant's forensic psychiatrists, Dr. Eileen Ryan, concluded in her expert report that defendant does not have a childhood history of behavior that is consistent with conduct disorder or antisocial personality disorder in adulthood, nor does he meet the criteria for antisocial personality disorder. All right, and just so you know, when they talk about antisocial personality disorder, that is just another way to talk about psychos, psychopaths, sociopaths. That all has to do with anti-personality disorder. It's just another way to say it. So basically his doctor says he does not have a childhood history of behavior that's consistent with being a psychopath or sociopath. Now, when we get down here, it says the court's concern with allowing the state's expert to conduct personality testing. This is where the judge is ruling against personality testing. But the court's concern with allowing the state's expert to conduct personality testing is twofold. First, the court is not convinced from the expert's explanation that the testing is within the scope of the rebuttal. No kidding. The first purpose identified, i.e. to ensure defendant's self-reported symptoms, particularly to Dr. Orr, are valid, might carry great importance if Dr. Orr's diagnoses were made largely based on defendant's self-reporting, but they were not. So basically her diagnosis was not on what Kohberger's sitting there telling her. Dr. Orr's neuropsychological examination included extensive interviews with defendant's family members, his co-workers, former teachers, and psychologists, former teachers and psychologists. So it means he had a psychologist before this, and an evaluation of defendant's health and educational records. Moreover, Dr. Orr specifically observed that on symptom inventories, defendant chose not to comment on any concerns about himself, and he showed very little insight into his behavior and emotions. So Kohberger's like, ain't nothing wrong with me. I don't know even what y'all are talking about. He doesn't even realize his symptoms. In other words, there was very little by way of self-reported symptoms. So he was like, no, I'm fine. I don't notice that anything's wrong with me. And that is usually a sign, if they don't know anything's wrong with them, that it is a clear, real condition that they have. They always say people that are crazy don't know they're crazy, but Kohberger's not crazy. He's got autism, but he doesn't realize that his symptoms of his autism are actually something that's different from other people, which is consistent with being a true diagnosis, in my opinion. Consequently, the court struggles to understand why it's necessary to test the validity of self-reported symptoms through personality testing. So, yeah. And remember what I read to you in 18207. If Kohberger was to go in there and they were to conduct personality testing and he would not cooperate, respond, then that would absolutely negate his own experts' testing, and they would eliminate his own experts' testing based on him not being complicit to the state's test. So it's a good thing that the judge did rule this way. And I hope that Kohberger goes in and doesn't try to evade the state's test, because if he does, that will negate his test from his expert. That's clearly written in 18207. Okay, then down here it says, similarly, Dr. Ryan also observed during her forensic psychiatric examination of the defendant that he did not thrust forward his symptoms in a manner suggesting malingering, and in fact took great pains to minimize and deny psychiatric symptomology. So he's like, I don't know what you're talking about, doc. Weighing the marginal utility of personality testing in this case against the existing time constraints and the timing of the state's motion, considering its knowledge of the scope of the defense's agreement, the court will not allow it. So good job there, Judge. Now, when it gets down here to the purpose of the defense being at the examination, I mean, I kind of like the way the judge wrote his ruling on this, even though it's not what we want, but I can agree with his ruling. Finally, the state seeks to exclude defense counsel from its examination, asserting defendant has no Sixth Amendment right to the presence of counsel at the examination. And it says, according to Dr. Redacted, defense counsel's presence would interfere with the validity of the examination. Now, this first part is where I call BS on the state right here, okay? Because this is why the judge ruled in favor of the prosecution to not have defense counsel present. Because the doctor that they replaced their other doctor with that said, I'm not going to do this because you need to let the defense counsel be present. Well, the new doctor that they got says counsel's presence would interfere with the validity of the examination. So they got a new doctor that said just the opposite. And because the doctor said this, the judge ruled with it because that's the way the statute basically says. For examinations of the defendant by the prosecution, such as those permitted by 18207, we already went over that, the standards the state that the defense attorney should be present at the evaluation only at the request of the evaluator for reasons relating to the effectiveness of the evaluation. If present, the attorney may actively participate only if requested to do so by the evaluator. So, if the defense counsel's presence in that examination is only due on 18207 is only at the request of the evaluator, and then their active participation, if they were allowed there, would only be governed by the evaluator themselves. So I'm trying to say is by them trying to get their doctor to not allow defense counsel, their doctor quit, said, I'm not doing that, I'm out. They got a new doctor that said, okay, I'll go along with it, and I don't want defense counsel in there. And because he said that, or she said that, then the judge reverted to the rule that only at the request of the evaluator can the defense counsel be present. So, to summarize, the state's expert quit because the state would not allow his defense counsel to be present at the examination, the defense counsel. The new doctor requests that defense counsel not be present, and because of that request, the judge follows precedent, allowing the wishes of the doctor to rule in the judgment. Let's hope this doesn't come back and bite. So in summary, there was a couple of losses and a win in there, but really the things that are important, I mean, they get a little bit of extra time on their guilt phase expert rebuttal disclosure. Not as much time as they would like, so the judge kind of held that into check. The judge did rule in favor of the defense that they can't do personality testing, which that was going to be a slick backdoor way to do some things during the guilt phase of the trial that they're talking about doing during the sentencing phase. And the thing we have to keep our eyes open for, though, is for some reason they did not want defense counsel to be present in that examination so much that they got their state expert witness to absolutely leave the case because of it. And their new expert is willing to go along with it. So shenanigans could be at play as it relates to that. And what I can foresee happening is the state's awareness that Bryan Kohberger is not going to want to cooperate with that type of testing with the state. And according to 18207, if he does not cooperate with that testing, then it will actually, if that doctor says he wouldn't cooperate, so we couldn't complete our tests, then the defense experts' tests have to be thrown out because that's what 18207 says. So that may be possibly their strategy right there. So we'll just have to wait and see. And So the things that we're still waiting on right now that are really pressing are obviously the defense's proffer for the alternative suspect, and then the May 15th hearing on the pretrial motions where they're going to discuss that. Then between now and the trial, I assure you, the defense has not given up on all their attempts to remove the death penalty before this trial. Even as you heard Dateline, if you watched the Dateline special, say they had an attorney in there talking about death penalty qualified jurors and the extra things that they must agree to be considered a death penalty qualified juror, and how much more likely they were to convict in the guilt phase. The defense knows that. They've said it over and over, and that's what's been first and foremost in all of their attempts to get rid of the death penalty. It's not because they think Kohberger is going to be sentenced to death if he's found guilty. It's because they want to seat the proper jury, because they know they've got an innocent client, and we know we've now found evidence of his innocence that is overwhelming. So you can bet between now and the trial, the defense is going to come up with a few things. I mean, it's going to happen. One, they're going to file one other motion to remove that death penalty at least, and it's going to be related to discovery. They're not done with that because there's a lot of discovery that was never presented to the defense in the way of the IGG with the FBI's stuff, the subpoenas they were never able to obtain, and a ton of video that has disappeared from the evidence locker at the police department. So that has not been brought up, and it will be, I assure you, because it's been verified in court now that they didn't receive some of those things. So I'm waiting for that. I'm waiting for the alternative suspect evidence to be presented. And then between now and the trial, you can bet that they're going to file something as it relates to the alibi and ways to corroborate it that they haven't already done. So there's some big things that'll happen between now and the trial that we need to keep our eyes open for, but we're going to keep on going. I'll have that other video out to you that is the one that I believe proves beyond a shadow of a doubt that the state's case is false against Bryan Kohberger. And that's the fact that not one of those vehicles from Washington State University to the crime scene is Bryan Kohberger's car, and it can be proven now through the court record and through evidence. And I will have that one out to you soon. But in the meantime, please like and subscribe to the channel. Post your comments, thoughts, criticisms. And until next time, Pavarotti is out.